At the stroke of the midnight hour, when the world sleeps, India will awake to life and freedom.
और जिस चीज से मुल्क को फायदा नहीं होता है, उस चीज से आकर हमको खुद को भी नुकसान होता है। वो चीज हमें समझ के हमें जो हिंदुस्तान आज सदियों के बाद एक हुआ है और एक मौका मिला है, वो घुमाना नहीं चाहिए।
आजादी का अमृत महोत्सव 75वें स्वतंत्रता दिवस पर आप सभी को और विश्व भर में भारत को प्रेम करने वाले, लोकतंत्र को प्रेम करने वाले सभी को बहुत बहुत शुभकामनाएं।
It is where our laws are framed, the country's future is debated, and the people's representatives are held accountable. It is India's seat of government, and all the important laws are passed right here in this iconic circular edifice, Parliament of India.
August 15, 1947 seems a long time ago. It indeed was. A 7.5 decade is a long period of time. India was different then. India is different now. Namaskar, hello and welcome viewers. You're watching the special presentation of Sansad TV. As we celebrate Azadi Ka Amrit Mahotsav, we need to pause and reflect upon the landmark legislations that have shaped our country. These laws highlight the transformation of the economy from agriculture to services, from shortages to surpluses, from basic survival to global goals. So get ready for this speed ride.
India inherited an impoverished land from the clutches of British colonialism. Ours is an extremely hard-earned independence. Our freedom struggle is an epitome of unfathomable endurance, grit and determination, and the urge to excel. That there's nothing to fear but complete freedom to aspire and achieve. Leaders of India gave new life to the country, lifting it from famished deprivation to food surplus status and creating infrastructure for generations to come. The Election Commission of India was constituted on January 25, 1950, just a day before the Constitution came into force. It is no coincidence that Indian Republic's first major legislative measure was to implement its constitutional commitment to usher in universal adult franchise. What has fleshed out the world's biggest ever experiment in democracy is a set of two laws bearing the same name, which was borrowed from Britain, the Representation of Peoples Act 1950 and 1951. The RP Act 1950 was enacted to provide for the allocation of seats and delimitation of constituencies to lay down qualification of voters. The RP Act 1951 was enacted to regulate the conduct of elections. But who could vote in these elections? Well, the citizens of India. So the Citizenship Act 1955 came into effect. Persons born in India between 26 January 1950 and 1st July 1987 automatically received citizenship by birth regardless of the nationalities of their parents. Between 1st July 1987 and 3rd December 2004, citizenship by birth was granted if at least one parent was a citizen. The Citizenship Amendment Act 2019 was passed by Parliament of India on 11 December 2019.
उस विधेयक के बारे में अंतिम फैसला आप सबकी सहमति से होगा।
It amended the Parent Act by providing a pathway to Indian citizenship for persecuted religious minorities from Afghanistan, Bangladesh and Pakistan who are Hindus, Sikhs, Buddhists, Jains, Parsis or Christians and arrived in India before the end of December 2014.
कि जो बिल है वो किसी के प्रति, किसी भी धर्म के प्रति भेदभाव से युक्त नहीं है। केवल और केवल उन लघुमतियों के प्रति ये बिल एक पॉजिटिव भाव लेकर आया है जो ये 3 देशों के अंदर प्रताड़ित है, और जो प्रताड़ित है वो शरणार्थी, वो शरण में आता है। माननीय
Redrawing the political map of India was of paramount importance post-independence, as India saw political movements for the creation of new states on linguistic lines. India treaded cautiously in the wake of the blood-spattered partition. How did we navigate our way? Let's find out.
The States Reorganisation Act 1956 was a major reform of the boundaries of Indian states and territories, organizing them along linguistic lines. After 1956, the acceptance of the principle of linguistic states did not mean that all states immediately became linguistic. Language alone did not remain the sole basis for reorganization of states. Later on, the regional culture and complaints of regional imbalance led to demands of smaller states. The bifurcation of Andhra Pradesh and Telangana, Uttar Pradesh and Uttarakhand, Bihar and Jharkhand, Madhya Pradesh and Chhattisgarh are recent examples of reorganization of Indian states.
A vast majority of people live at the grassroots levels in the rural and remote areas, untouched by the modern ways. The Gandhian dream of Gram Swaraj entered the realm of possibility in 1992 when the Narasimha Rao government pushed through the 73rd Constitutional Amendment.
Panchayat institutions are the vehicles of political empowerment of people at the grassroots level for shaping their own destiny. The 73rd and 74th Constitutional Amendments were passed by Parliament in December 1992. Through these amendments, local self-governance was introduced in rural and urban India. Panchayats cover about 96% of India's more than 5.8 lakh villages and nearly 99.6% of the rural population. As of 2020, there were about 3 million elected representatives at all levels of Panchayat, and nearly 1.3 million were women.
Steps have been taken for years and years, and every year we are taking new steps in order to empower women.
The principle of gender equality is enshrined in Indian Constitution in its preamble, fundamental rights, duties and directive principles. The Empowerment Acts have acted as powerful tools against exploitation and harassment of women.
The social reformers of the 19th and early 20th centuries have striven hard for the abolition of various social evils, including the evil of dowry system. On 24th April 1959, the Dowry Prohibition Bill was introduced in the Lok Sabha. After some discussion, the bill was referred to a joint committee of both houses of Parliament. The committee presented its report with some amendments. Both the houses did not agree with the amendments, and ultimately the bill was considered at the joint sittings of both houses of Parliament held on 6th and 9th of May 1969. The introduction of the Rajya Sabha Bill against women's indecent representation in 1986 was in response to a women's movement which called for a legislative action against the negative depiction of women in the country. The bill was introduced by Margaret Alva in the Rajya Sabha and became law in October 1987. It was implemented to ensure that women's representation in the media was not indecent through ads, magazines, publications, and illustrations. Sexual harassment is any unwelcome sexually defined behavior which can range from misbehavior of an irritating nature to the most serious forms such as sexual abuse, assault, including rape. The Sexual Harassment of Women, Prevention, Prohibition and Redressal Act of 2013 defines sexual harassment to include any unwelcome acts or behavior, whether directly or by implication.
Those in favor may say aye. Aye. Those against may say no. I think the ayes have it. The ayes have it. The motion is adopted.
Thousands of deaths are reported from unsafe abortions due to lack of trained abortion providers, lack of knowledge about the legality of abortion, and the availability of safe services, compounded by social stigma surrounding abortion. The Medical Termination of Pregnancy Amendment Act of 2021 that amends the Parent Act of 1971 enhanced the upper gestation limit from 20 to 24 weeks for special categories of women. Special category includes survivors of rape, victims of incest, and other vulnerable women like differently abled women and minors.
Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted.
The Muslim Women Protection of Rights on Divorce Act was a controversial legislation passed by Parliament of India in 1986 to protect the rights of Muslim women who have been divorced or have obtained divorce from their husbands and to provide for matters connected therewith. The act was passed by the Rajiv Gandhi government to nullify the decision in the Shah Bano case. However, the Muslim Women Protection of Rights on Marriage Act 2019 declares the instant divorce granted by pronouncement of triple talaq as void and illegal. It provides for imprisonment for a term up to 3 years and fine to the husband who practices instant triple talaq.
Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The clause 4 is adopted.
India has a wide range of laws to protect children, and child protection is increasingly accepted as a core component of social development in our country.
Both boys and girls in India face early marriage, domestic abuse, sexual violence, violence at home and in school, trafficking, online violence, child labor and bullying. India has a fairly comprehensive policy and legal framework addressing the rights and protection of children, providing opportunities to ensure that all children have equal access to quality protection and services. The core child protection legislation for children is enshrined in 4 main laws. The Juvenile Justice Care and Protection Act of 2000, amended in 2015, the Protection of Child Marriage Act 2006, the Protection of Children from Sexual Offences Act 2012, and the Child Labour Prohibition and Regulation Act of 1986, amended in 2016. The Right of Children to Free and Compulsory Education Act, or RT Act, is an act of the Parliament enacted on 4th August 2009, which describes the modalities of the importance of free and compulsory education for children between 6 and 14 in India under Article 21A of Indian Constitution. India became one of 135 countries to make education a fundamental right of every child when the Act came into force on 1st April 2010.
Our country also has specific laws that guard against the discrimination and exploitation of marginalized communities. Let's take a look.
For all the social reforms made during colonial rule, the Constitution abolished untouchability for the first time. The Republic took another 5 years to back the abolition with a law that penalizes various manifestations of untouchability. The Protection of Civil Rights Act 1955, Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989 was also passed to deal with more violent caste-driven offences. In 2018, the government had enacted the amendments saying the Scheduled Castes and Scheduled Tribes continued to face the social stigma, poverty and humiliation, which they had been subjected to for centuries. The 2018 Act had nullified a March 20th judgment of the Supreme Court, which allowed anticipatory bail to those booked for committing atrocities against scheduled castes and scheduled tribe members. The original 1989 Act bars anticipatory bail. In 2013, Parliament also passed Prohibition of Employment as Manual Scavengers 2013 with a greater emphasis on rehabilitation. The Act bans the use of any individual for manually cleaning, carrying, disposing of, or otherwise handling in any manner human excreta till its disposal.
Given the brisk pace of development in the world today, the development of New India is expected to be achieved sooner than envisioned. This cannot be achieved solely by conventional methods. Here are some of the landmark legislations which have had colossal economic implications for our country.
The Government of India issued the Banking Companies Acquisition and Transfer of Undertakings Ordinance 1969 and nationalized the 14 largest commercial banks with effect from the midnight of 19 July 1969. The year 1991 is a milestone in the history of independent India. The country was facing an acute economic crisis, which was triggered by an increase in world crude oil prices, following Saddam Hussein's onslaught of Kuwait in August 1990. The balance of payment situation became unmanageable. There was a sharp reduction in the foreign exchange reserves due to sharp decline in capital inflows. It was a serious threat to the sustainability of the growth process. India was close to default. The economic reform initiated in 1991, followed by further measures undertaken by successive governments, have helped our country emerge as one of the fastest growing economies in the world. Foreign Exchange Management Act of 1999 came into force by an Act of Parliament. This new act was in consonance with the frameworks of World Trade Organization. It also paved way for the Prevention of Money Laundering Act of 2002, which came into effect from July 1, 2005. The Fiscal Responsibility and Budget Management Bill was introduced in Parliament of India in the year 2000 by Atal Bihari Vajpayee government for providing legal backing to the fiscal discipline to be institutionalized in the country. The Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, more commonly known by its shorter name SARFAESI Act, is a legislation that allows bank and other financial organizations to recover bad loans effectively. India embraced the Goods and Services Tax, biggest taxation reform since independence, on midnight, in a move that marked the culmination of country's long and checkered journey towards a uniform, all-encompassing, pan-India indirect tax system.
GST. Good and Simple Tax.
The Insolvency and Bankruptcy Code, a reform enacted in 2016, amalgamates various laws relating to insolvency resolution of business firms. It lays down clear-cut and faster insolvency proceedings to help creditors, such as banks, recover dues and prevent bad loans, a key drag on the economy.
Now, the ordinance is necessary because this act itself provides a 180-day time period in which a resolution is to be completed.
The Parliament passed the much-talked-about labour codes to reform the labour laws, which have been unchanged since independence. The new set of regulations consolidates 44 labour laws under 4 categories of codes, namely Wage Code, Social Security Code, Occupational Safety, Health and Working Conditions Code, and the Industrial Relations Code.
Sri Santosh Kumar Gangwar to move that bill be passed.
Sir, I move that the bill be passed.
The Taxation Laws Amendment Act 2021 aims to withdraw tax demands made using a 2012 retrospective legislation to tax the indirect transfer of Indian assets. The aim of the Amendment Act is to bring tax certainty and ensure that once specified conditions are fulfilled, the pending income tax proceedings shall be withdrawn. Demand, if any, shall be nullified.
Security and border protection are traditionally a high priority for the Government of India. Successive laws have further fortified it.
The National Security Act is an act that empowers the government to detain a person if the authorities are satisfied that he or she is a threat to national security or to prevent him or her from disrupting public order. Armed Forces Special Powers Act, or ASFA, is a parliamentary act that grants special powers to the Indian Armed Forces and the state and the paramilitary forces in areas classified as disturbed areas. The objective of this act is to maintain law and order in disturbed areas. The Unlawful Activities Prevention Act of 1967 is meant to outlaw and penalize unlawful and terrorist activities. In 2019, the Parliament carried out certain amendments to the Act, and the same was notified later. The most significant change brought about by the amendment was that it altered Section 35 and gave central government the power to notify an individual as the terrorist under Schedule 4 of the Act.
Earlier, every legislation, except on defence, external affairs and communications, began with an exception clause stating that the law will apply to the whole of India except Jammu and Kashmir. That changed with the historic abrogation of Article 370.
Article 370 of Indian Constitution gave special status to Jammu and Kashmir. Jammu and Kashmir was administered by India as a state from 1954 to 31st October 2019, and Article 370 conferred on it the power to have a separate constitution, a state flag and autonomy of internal administration. On 5th August 2019, the Government of India issued a presidential order superseding the 1954 order and making all the provisions of Indian Constitution applicable to Jammu and Kashmir. The order was based on the resolution passed in both houses of Indian Parliament with 2/3 majority. In addition, the Jammu and Kashmir Reorganisation Act 2019 was passed by Parliament, enacting the division of state of Jammu and Kashmir into two UTs to be called UT of Jammu and Kashmir and UT of Ladakh.
Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The bill is passed.
A citizen-centered approach sees citizens as actors, not as residuals of other institutions, puts citizen empowerment at the heart of democratic progress. Important legislations have ensured exactly that.
The Right to Information is an act of Parliament which sets out the rules and procedures regarding citizens' right to information. The RTI Act allows any Indian citizen to participate in governance by enabling her or him to seek information about central and state government activities.
Seek your permission and rise to move that the bill be passed.
The new Consumer Protection Act